apologise on behalf of Professor Fionnuala na Aoláin, who is also based at the University of Minnesota and had to return there this weekend. She's a colleague of ours in Transitional Justice Institute. I was just recalling that one of the last times I stood in this long gallery many, many years ago was when President Bill Clinton was visiting Northern Ireland. And I just recalled that my first name being Monica wasn't actually a great advantage at that particular time. But that memory just came back to me as I was sitting up here. So I haven't started with that. It can only get better. This talk is basically looking at the issue of the new strategy that both DHS, SPS and the DOJ have introduced in relation to domestic and sexual violence. So I'll be going down through this and looking at some of the issues that the proposals have made and some of the gaps in it. I do believe that when we do develop these strategies, context is everything. And I am a bit concerned that the strategy missed some of the particular contextual features of Northern Ireland, particularly given that we're in a transformation, and in a transformation in every sense. Though having just heard Joan's presentation, one would question just how much of a transformation we are in, given the huge discrepancy in those figures in relation to male and female employment. And quite a lot of what the three of us are going to be saying is actually very much related. So we question what kind of transformation, if we are talking about a change in attitudes, a change in systems, and a change in policies. And again, the second major gap that I'm concerned about is the lack of a human rights-based framework. Nearly all countries now have been attending to this issue when they're developing their strategies. We have the advantage of the Human Rights Act being incorporated into domestic law since the year 2000. And when you hit the search button on the strategy, the Human Rights Act does not come up once. And it's not referred to, which is a bit of a concern. But there's also other major human rights pieces of international legislation that are not there. And I just was a bit concerned, major concern, that as we go forward now with this up until 2020, that should have been at the centre. The strategy starts off with those words. The very first paragraph of the strategy starts off with the importance of human rights. And then to leave out the actual detail of how you would apply these and how they would become a benchmark and how you would monitor by them is missing. It is a global phenomenon. And it's not particular to Northern Ireland, but it does take on Pacific modalities here, and particularly given the years of the Troubles. And there isn't much of a reference in the strategy to the fact that we went through 30 years of conflict. That conflict had a huge impact, not just visually, but actually in reality. This is a mural that I pass quite frequently on the way to the university, and these are our brothers. Brothers in arms, together we will defend our native land. And the question was, how did they see themselves as defenders? And what role had women in the conflict in terms of having to put up with the fact that the whole context of policing was so very different in relation to domestic violence? And I undertook some of that research 20 years ago. And of course, the whole issue of the word terrorism. On the one side, it was seen as political terrorism. I used to train police officers, still do, and they said they had joined the police to fight terrorism. And when I used to engage with them and what they meant by this word, it was very clear that it was the public face of the conflict. And I asked them how did they see themselves engaging with other types of terror behind closed doors and in much more private forms. And they actually used to say that they had signed up they preferred to serve dog licenses than to go out and deal with domestic violence. So that was 20 years ago, and things have changed. But by then, domestic violence was designated as ordinary decent crime. When I first sat down in all the police stations to count the statistics manually, and they were kept very poorly at that time, I noticed this category, ODC. It was quite a shock to see it listed as ordinary decent crime, but a bigger shock to see murders as ordinary decent murders, ODMs. So we have come some way, I hope, since then. And in the study, which was named Bringing It Out in the Open, the title was very appropriate because it had been so much hidden. I did list the types of injuries, and they're on the front of the book, and they kind of jump out at you just about how serious this issue was back then. And this is the physical types of injuries, and I was trying to do some work with casualty departments in the hospital at the time to show what they needed to look at and how to identify this. And it is quite difficult in terms of it's every part of the body. But there's been a lot of good work now starting with the health service in identifying this during pregnancy, but also at other stages. So it's not just a domestic. And if clearly the policing issue, it was not seen as such a hard issue, it was seen as a soft issue, an ordinary crime. And my question is actually that do we only pay attention to these issues when it becomes extraordinary rather than ordinary? And that's also a problem. As we know, William Hague had his big conference on sexual violence this past year, and the argument was that so much attention was paid to extraordinary rather than the everyday ordinary. And most of it was focusing on Africa rather than our own domestic situation. So there were some criticisms about that. And I look at this issue of what makes ordinary extraordinary, and what should not be considered extraordinary can be very ordinary. But we had no-go areas, we had barriers, there was legal and illegal weapons that were being used, we had a much higher homicide rate here, many more women were being killed here as a result of the availability of weapons. And there was a gender culture at that time, which Joan has referred to in her last point, that still very much exists, which was engaging with women's organisations in particular who were addressing this issue. And were addressing it from a policy context. And there was a lack of that engagement. And in fact, there was an antagonism at times towards that engagement. I do recall myself, people saying, is that the crowd that split up families? And that was a reference to Women's Aid. Now, today that would no longer be said, but you can imagine, and Women's Aid celebrate their 40th anniversary this year, that 40 years ago, when brave and courageous women were setting up shelters and refuges, that's the context in which they were working. And so there was very much a lack of confidence in the state institutions to deal with this crime, particularly from the criminal justice side, but also from health and social services. It failed to capture the severity, there was an insensitivity to victims' needs. The crimes were largely left unpunished, and so the policy was non-interference, very laissez-faire, hands-off. And so how did we get from there to here? And it is now, as Mike said in his introductory remarks, we have good data, much better data, but I'll be critical of that data in a moment in terms of the definition. But this shows you just how much time, resources, and I haven't put up the costs, and it's good to see the strategy does look at the costs. So, you know, from even rehousing families, 700 each year having to be rehoused by the executive, housing executive, and that's in the public sector, right through to the murders. And the murders will become significant in a moment. So we have shifted the focus from custom, very much seen as a culture. You make your bed, you lie in it, is what I was told years and years, over and over again, that marriage was for life and that was it. And at what cost did you stay together? And of course the costs are now there, economically as well as socially. So it was moved from culture to courts. It's been moved from the private to the public. It's been moved from the personal to the political. And all of those were obviously this little cartoon from many years ago. And it shows the affectionate husband saying, now come on, Polly, if I am a little irritable, it'll all be over in a minute. This is, of course, whilst he's wrecked the place. And here we have you know, the connections with attempting to break the silence. It wasn't just here, it was elsewhere. And it came from the ground up. It was a bottom-up women's movement that raised those issues and made it a policy issue. And now we have to look at how policy has responded to that. So it is about making private harms a public concern, and that's the connection with Catherine, who will follow me in relation to dealing with the past. That these are public concerns, that we have changed the thinking from it being your own home, a private home, no interference by the state being seen as too paternalistic and over-interfering when it moves in. And we have moved from that to now providing personal protection orders, occupation orders, providing legal aid in order to do that. And it's been an unfinished business. We've worked hard at moving the policy, amending the legislation. But the last piece has been missing, which is the application of international human rights standards. My first criticism of the current strategy would be its definition. We really do need, by now, to be much more specific. This is not elder abuse, this is not child abuse, this is intimate partner violence. And if we do not start looking at it like that, then we're clouding the issue, we're confusing the issue, and we're adding others in. And we're not getting the picture. Elder abuse is a different issue, child abuse is a different issue, sibling abuse is a different issue. Intimate partner violence is the main form of the violence, and we need to call it that. And it has been called that by CEDAW. It has also been framed in the context of coercive, intentional control, which I think is also important, about looking at how it perpetuates and enforces gender inequality, which makes the links with what happens in the private and the public in terms of if you got finances, are you in your full-time work, have you got the opportunities to be employed and go up the ranks. All of that actually it has to be integrated with this whole notion of power, what happens in public, what happens in private, and in these spaces. And I could talk a bit more about that in terms of invisible, hidden and visible forms of power, but we already heard some of that from Joan in terms of those who are considered to be at the highest levels of executive and making decisions, and those who are not. But the last strategy and the one previous to the current one missed this connection. And this word is constantly written in irrespective of gender. Sometimes do we do harm when we are looking at policies and trying to neutralise them. And that, it's really, we need to be moving away from that. It is gender specific. We need to know how much it is gender specific. We need to know how many females are the victims. We need to know how many males are the victims. We need to know if they're in same-sex relationships or not as male victims. We need to know all that. And it's not difficult to devise and define the definition so that we can get the correct data. Otherwise, we will remain confusing the data with other kinds of abuse. So a uniform definition is needed. The United States has identified that. It now introduces this term intimate personal violence and keeps good data as a result. And the arguments are that we will continue to have global disparities unless researchers attempt to understand this and have a more commonality in what they're talking about. This is another criticism beyond the definition, that there's an absence of homicide reviews. In 2004, they introduced homicide reviews in the legislation in the UK. This is 2015, and we've not had one homicide review in Northern Ireland. You saw the extent of murders. We want to know what happens. Could we have prevented them? Because that's, the actual taking of life. And in some work that I started to do many years in the coroner's court and didn't take it any further, I was shocked to the extent to which I saw that the deaths could be prevented. It was in the coroner's court, everyone opens up because it's not an adversarial process, and you do have information being provided. But what I found was a lack of information being exchanged about the danger that women were in. And often it wasn't just femicide, it was familicide, the women and the children being murdered. And we've had some recent cases of that. There have been an inquiry into one of the more famous cases in Derry, but there hasn't been any homicide reviews. And so that's a real gap. And we're not meeting the international standards that ask for good policy and practice, particularly when we've introduced domestic legislation for that to be implemented. We know they do not come out of the blue. I know that from my own research when we did the study through the courts on manslaughter, murder, and on grievous bodily harm and attempted murder, that they were known to the justice system. And fortunately now we have got a multi-agency risk assessment conference which does identify high-risk individuals, But we need to add to that, and there is an absence of that in terms of the current strategy. We have come, as I said, to the understanding that we don't move the women and children out of the homes, we leave them and we move the danger from them. That it's a process, not an event. We've said that 1,000 times. Too often in the past, when I sat in the courts, it was identified as a one-off incident, and too often the judiciary were almost forcing the victims into talking about the one-off incident as opposed to a pattern of behaviour, a career of behaviour, a process. And leaving is also a process. And so victims need support at different stages, continuity and consistency. This is an old table that I drew up at that time and could be added to now. But all of these agencies need to be pulled in, not just in the public sector, but also in the voluntary sector and indeed in the faith communities, as we can now hear in terms of ideological discussions going on about different forms of law, not just public law, but canon law and Sharia, etc. But I don't have time to talk about that. But it's still too much of a balance, and that's why human rights are so important. That's why the international standards are so important. Custom and practice, or data protection overruling human rights, and that remains a concern. The systemic issues are still there. You've heard some of these from Joan in terms of the economic system, the political system that sustain these inequalities, what the women themselves had to say, which was quite interesting, in terms of them actually saying that they didn't feel encouraged or to use Joan's own word, which is good, I think, in some senses, but we can unpick it later, of cronyism. And where does that come from? So who's getting picked to move up the system? And who's getting the opportunities, or who's getting doors closed off, and who's having to go out and claim those opportunities in a way that they shouldn't have to? And the same Mike Nesbitt did the political system, and here's a good reflection of it downstairs, as indeed Aoláin is, in terms of who's making the decisions at that high executive legislative level. Are women at the table? And the cultural and religious norms I've already referred to. So there is a real gap if you do not then incorporate and integrate international human rights standards. I was surprised at the lack of reference to the European Convention on Human Rights, now incorporated as the Human Rights Act. There, in the appendix, there's reference to these other international standards, but very few examples of how they apply. And the last one's missing. The UK Convention, the European Convention, which is known as the Istanbul Convention, which the UK has now agreed to ratify. It still hasn't. I actually think the reason why it hasn't ratified it because it would have to look at its immigration standards, and we did a study recently on ethnic minorities and domestic violence in Northern Ireland to CEDAW when the UK was being examined every 4 years, and we found some huge gaps there. We called it forced dependency, and we also found that it was leading to destitution, the way that some of the policies and legislation are operating against those who have no recourse to public funds or have visa difficulties because they've come with the husband. There used to be an old Russian proverb, I don't know if you've ever heard it. I thought I saw two people, but it was only a man and his wife. And very much the case on the immigration study that we did in terms of asylum seekers and refugees was very much about, I thought I saw two people, but it was only a man and his wife. And the difficulty was when the wife was in a domestic violence relationship, all kinds of problems were arising in terms of access to both social security and more protective status. But that Istanbul Convention would have introduced those standards. And so it's surprising that the strategy is silent on that. When I was Chief Commissioner of Human Rights, I loved this cartoon that Ian Knox drew. That's me, by the way, with the big earrings. And it says, human rights is not a pick and mix. And at that time, I was trying to surface these rights because we were told that the only rights had to be particular to the conflict. And of course, Catherine will pick this up. What rights were particular to the conflict? And that, domestic violence and sexual violence weren't particular to our conflict. Interesting that these issues are coming up so much in the media recently. One of the points that my colleague, Fionnuala makes is that without recognising that victims are rights bearers, they bear rights, that the strategy runs the risk of relegating the individuals to the status of pleaders, that they're pleading for their protection, rather than as individual, independent individuals with rights and that status as of right. And that's what the Human Rights Act has done. It has given us that status. It is being used by the courts as individuals with rights and status. And indeed the international standards, and I don't have time to talk about it, also talk about positive measures, special temporary measures that need to be put in place, which we're now starting to do in the courts with the criminal justice system when victims are giving evidence. But how much more we should be doing that. And I'm concerned when I see that the prosecution service, when I ask that question, how often are these being used? They're not being used that much, and women don't know about them. Victims, vulnerable adults in particular, having to go out of their way to seek them. And then paying due diligence. The state actually going out of its way to make sure that it prevents an action taken that could cause the end of life. So there's lots of jurisprudence. These are the articles in the Human Rights Act. They've all been used. There's all cases at the European Court that have used them. I list them in your policy brief. You can read them for yourself. And once these are declared at the European Court, we follow them and take account of them. And that's why they're so important. And they've actually have shown that police officers need to be much more vigilant, that if they are aware that there is women in danger, and they have been criticised in other countries for not doing that, that they need to move to protect and not to use that old culture that nothing much can be done, that their legislation has provided effective measures, that those effective measures should be in place. And of course there's been lots of questions here, how often were personal protection orders enforced in Northern Ireland, and occupation orders enforced in Northern Ireland against the perpetrator. How often were they brought to court for not enforcing those or not responding to those? And CEDAW, which is the big international convention, has paid attention. I would recommend you to look at comment General Recommendation 30, which is most recent. It specifically would apply to Northern Ireland. It's an excellent comment. And down through it, it talks about particular countries that have come out of an experience of political conflict and how much more that needs to be taken on board when we talk about domestic violence. We now have the right under an optional protocol to ask CEDAW to take on in particular investigations in specific countries. And they've done that, and they have reported. And some of these cases have been extremely important, where they've said that human rights to life and integrity cannot be superseded by other rights, such as the right to property, which often has happened in cultures where they have argued that the Englishman's home is his castle, where the state has not a right to interfere about what goes on behind closed doors, that the privacy supersedes the right to that. And of course the CEDAW and all the other international standards say that's not the case. The right to bodily integrity and the right to life are more important. And likewise, it has argued that domestic violence violates the equal rights of women. And again, that goes back to that issue of intentional coercive control and use of power to subordinate or keep a victim in place for long periods of time. And I often argued that in Northern Ireland, it wasn't the case that men were more violent than anywhere else. It was simply that women were contained in the situation for longer because of the lack of responses. I know that we have now responded, but we should not ever regress, and we should be building, and that's what the human rights standards do. They show how they can be applied, and in fact, many of these talk about the use of affirmative action, the use of positive measures, indeed the use of quotas. So if they start debating downstairs in the chamber about quotas being illegal, we need to tell our politicians, we need to tell our legislators they're not. They're actually recommended by the international standards, and we won't change Jones' data and the team's data if we do not start talking about what can be done to change these practices. So in the end, the last resolution that's been introduced and very briefly I'll speak to it, is the UN Security Council Resolution 1325, which talks about the role of women in post-conflict. And unfortunately, the UK government has argued it will not apply to Northern Ireland because it doesn't recognise our conflict as an international or interstate conflict. It's just a little domestic conflict. And it should apply. And CEDAW has criticised the UK government for its lack of application. And if it did apply, again, we could be doing much more in relation to changing the situation that Joan's data, and I'm sure Catherine's will also speak to, which is how far women are behind. And indeed, we're in danger, I know from the public appointments data, we're going backwards. There are fewer women now chairing public appointment bodies than there were in 1998 at the time of the peace agreement. And so how can this be happening? So our new relationship, as Fionnuala, my colleague, asks, well, what do these new agreements, what do these new peace agreements, and what do constitutions do? It's not just the Egyptian women who should be asking that question of the Muslim Brotherhood. What do constitutions do to women, and what do they do for women? And they're extremely important when you produce new agreements, when you produce constitutions, when you produce bills of rights, or you produce government strategies. So in post-conflict, we need to be looking at prevention, protection and promotion. And if we are going to change these attitudes, if we are going to introduce good policies that can be applied and by which we can have benchmarks and measurements and have standards monitored, then the system needs to take on board these human rights standards. Thank you. And I finish with that because it's the 40th year of Women's Aid. And I think it's a great banner. The year was 2011. It was 100 years on from 1911 when women first got the vote. And there was a big march in Belfast. And Women's Aid carried the banner which said, "Until women and children are safe." And I'll just finish on a little note which I just heard from Windsor Women's Centre this afternoon, which is that they're now experiencing cuts to the extent that the access to support that they're giving to women in their communities will all disappear in March. And so women that they were helping in the communities, some experiencing sexual abuse, some experiencing physical and psychological abuse, other women who they were managing to keep out of prison. These are really important support mechanisms. They're accessible, they're in the local communities, and in March, the centre has told me their funds are cut and the support is going. So my view is, are we progressing in 2015 or are we regressing? Thank you.